This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions expressed on this program are those of the program host and guests and are not those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Call in with your questions and comments at 340-1590, 340-1590. Now with Ask a Lawyer, here's your host, Attorney Stuart M. Address.
Good morning. This is Stuart Address, and this is Ask a Lawyer. And I'm hoping that you folks will call in with your questions. If you have a potential legal problem, give me a call. Maybe I can give you some free, quick advice. Maybe I can let you know whether you really do need a lawyer or whether you don't need a lawyer. If you have some comments about the legal system or maybe a really good lawyer joke, give us a call. Anyway, as I said, I am Stuart Address, and I am a real lawyer, at least according to the Florida Bar. And my office is in Stewart, Florida. That does sometimes create a little confusion.
What's your Stewart address? Stewart address.
That's the problem.
I couldn't help myself.
Nobody can. I started when I was a kid, and then once I got an office in Stewart, it really got bad.
Yeah.
I had a call not too long ago, and my paralegal put it through to me, and I answer the phone, Stewart Address, and she says, yes. And I said, hello? She says, Stewart Address? I said, yes. And she said, Stewart Address. I said, yes, this is Stewart Address. And she hung up. Well, she was really calling for our Stewart Address. And she just got really confused. Now, I don't know.
It's kind of like who's on first.
I was going to say, if you're a fan of Abbott and Costello, that's exactly what it sounded like. I don't think it was quite as funny as Abbott and Costello, but it was still really interesting. I don't know whether this prospective client ever made contact with us or whether she just walked away confused. So anyway, we were talking last week about the McDonald's hot coffee case. And somebody told me, gee, you forgot to mention something really important. This is why lawyers have paralegals.
Okay.
Sometimes paralegals...
So you went back to your office.
That's right. And my paralegal looked at me and she wagged her finger and she said, you didn't tell one of the important pieces. And I said, what was that? And she tells me, and I said, oh, you're right. So I'll do it next week, which is today. So one of the important pieces is when we talked about the punitive damages being $2.8 million, which, of course, remember, that got reduced by the judge to $450,000.
Okay.
And then it got reduced by 20%.
So that first number was awarded by the jury.
By the jury.
Thinking that they could.
Right.
Okay.
There was a reason they awarded that number. It represented 2 days of coffee sales in the United States for McDonald's.
Okay, so that's how they got to that number.
That's how they got to that number.
All right.
So again,
So in other words, they could afford that.
That's right. Punitive damages are designed to not inflict,
Yeah, we didn't want to put them under.
Exactly. They're designed to inflict just enough pain to cause a company or a person to not do it again.
Right.
Now, some might say that 2 days of just coffee sales was woefully little. Maybe it should have been a $20 million
if you think about
damages. But really what the jury was doing, and everybody goes, oh, that's outrageous. But what the jury was doing after they heard the evidence was 2 days, coffee, U.S., that's not so bad. And
they would recoup that quickly.
Well, I would think so. And just so you folks out there have context as to, why that punitive damage verdict was that high. The other reason, another thing I did forget to say and was dutifully pointed out to me, I'll get her for that, was that McDonald's had a while earlier done its own internal study and determined the cost to retrofit its coffee pots so that they would not heat at such a high temperature. And they had determined that the cost, though not extraordinary, was more than was worth it given the potential for what the payout of claims would be.
Okay.
So the jury heard that and gets angry and decides, well, we're going to inflict some punishment. And so there are reasons that this happens, and sometimes when you just hear the number, cold because it's being reported on the news, you say that's ridiculous, but then you got to go behind the numbers. Matter of fact, there's somebody who I know was on WPSL. Was one of the reasons when I first moved here in '96, I was listening to WPSL. Paul Harvey used to always, and the rest of the story. And I used to wait through the commercial break just for the rest of the story because I knew it was going to be really good. And I knew it was going to sell me something that I had not imagined and that might change my perception of whatever it was he was talking about. And when you hear reports on the news, that's really what's going on.
We need a program like that now with everything that's in the news. Where's Paul Harvey today?
I don't know. I would enjoy listening to it again. And, well, at least with McDonald's, maybe I gave you a little bit of the rest of the story. Let me talk a little bit about, we again broached upon it last week before I go into a real substantive area, about relationship with attorneys and their clients.
Okay.
Which sometimes gets strained. And the primary reason, at least in my opinion, is lack of communication on the attorney's part. Now, there are a number of ways that can be resolved. I'm certainly not perfect. I don't think any attorney is. But in my office, we certainly do endeavor to solve some of these problems. One of them is to call your client back relatively quickly, whether it's a call, whether it's an email, what have you. They at least want a response. If they're calling you at 2 in the afternoon about their case, they have something on their mind. And the last thing they want is to wait to the next morning to hear from their lawyer. It may be really an inconsequential question to you. It may really have no bearing on what's going on in their case, but it popped into their head and it's important to them. And, sometimes we lose sight of that. So I think getting back to your clients obviously is very important. Letting them be heard. Now, I can be an offender here too. A lot of times you hear things and then you interject because there's a great question to ask at this point.
Well, that's called conversation.
Well, it is, but when you're talking to a prospective client in the office, that conversation may derail them. You may go down a path and they don't remember where they were in the story. As a matter of fact, I had a prospective client in just this week, and my notes indicated for my paralegal that there were 2 issues. And so he started to tell me a little bit about this first issue, and I started to deal with it, and question him in a lot of detail. And we got halfway through, and he said, well, that's really not what's important to me. I said, okay. What is it that's important to you? And it was the second issue. And so I said, okay, we went down a rabbit hole. So even I, sometimes it's right to interject, ask a question, but your clients really want to be heard. Whether it's a contingency fee case where they're not even paying you, you're getting money if you win, or an hourly case where they are paying you, they want to be heard. And if they're heard, very often, whatever the result of the case, they walk away feeling better about the system and about you. And clearly that's what you want. The other thing is I get calls and comments a lot of times, people calling me and say, well, I had a lawyer and, I'm not happy, blah, blah, blah. And I say, okay, do you have copies of these things that you're talking about? Well, no, my lawyer has them. Well, did you ever get any copies? Did you ask for any copies? No. I don't understand that. To me, a client should have everything that I have. So when we get, and it's great now that things so much are done by email. We get in a letter from, the other attorney. It goes out to the client by email. With a little note, either just FYI, it could be just that simple, for your information. Or sometimes, here's a letter and essentially about this and, give us a call so we can talk about whatever. But if the client is organized, the client is going to maintain a file with correspondence and pleadings and discovery, and a lot of clients really do that. Of course, a lot of clients just put them in a big bag and you can't find anything.
Or they're all over the house.
But,
Stuffed in this drawer over here.
but at least we've sent it. And I think that when they know they're getting the materials, even if they don't look at it, there's a sense of comfort because when I speak to clients whose attorneys have not done that, we often hear, I don't know what's going on in my case. Now, look.
Well, sometimes even if you do get a letter, you still don't know what's going on.
That's right.
Because it's just not in your lingo.
And it's not always the lawyer's fault, honestly.
Mm-hmm.
Sometimes, the client just didn't follow up and didn't, even try to talk to the paralegal or what have you. But very often it is the lawyer's fault. And not sending the materials along to the client, is part of the problem. So, I also tell my clients, if you have a question that you think is going to require some time, okay, give us a call. My paralegal initially will talk to you, and then either I'll talk to you or I'll give her information to convey back to you. But if you think it's something simple, either a question or a note, make sure you remember to ask such and such about X. Send me an email. Because I could be typing away on a 20-page brief, and that little flag comes up on my laptop that says mail. Well, I'm a little anal retentive. I got to go look and see what it is. And if it's relatively simple, I'll type a quick response. They get a response in a minute. I think that looks good too.
Sure.
Sometimes if I have a little bit of insomnia, they get a response at 3 a.m, which also seems a little bit impressive, I've heard. It also seems a little bit intimidating to certain attorneys.
You really want to know what's in your email.
Right. Yeah. Sometimes an attorney will come up the next morning at 5 o'clock or something and says, "Oh, I sent him an email at 3." He thinks, "Oh, boy, you must really be working hard." Go ahead, you think that. That's okay. So overall, it's all a matter of interaction. And it's not just lawyers and clients. It's, I got this bug, that deals with customer relations. It could be anywhere, any business, any customer. Then I point out now my son is 13, going to be 14 next month.
I'm sorry.
Yeah. I appreciate the condolences.
I'm a mom, you can tell, right?
And I point out to him a lot now when we're driving or we go into a store or something. Afterwards, I'll say, that was really good customer relations. They cared enough to
Does your son notice? Does he know?
Now he does.
Okay.
Yeah, now he does. He's become attuned to it, which is good because whatever endeavor he ultimately goes into, hopefully he'll carry that with him and realize that it's not always giving the answer the customer might want to hear, but it's giving them an answer, in an appropriate way. So it's one of my little bugs. I have a lot of them, and maybe as things come up, we'll find out some of them.
I think it's great to hold on to that notion that there should be customer service because it's slipping away.
It is, and sometimes when you find really good customer service, you notice it because it is slipping away. It used to be there were a lot more mom and pop businesses, and you'd become a regular. So it's sort of like Cheers. Everybody would know your name. There was a bagel shop I used to go to, and I'd walk in, and they'd already be making what I wanted because they knew it didn't vary. So if there may be a line, but I'd get up there, and all of a sudden it would be ready. And, well, we just know what you want. And there's something good about that. There were a couple of occasions in that same bagel shop where I get in there, I order, and they give me my stuff, and I go for my wallet. Oh, my goodness. Where's my wallet? I must have left it on my nightstand. I have no money. I have no credit cards. I have nothing.
And now I owe you money.
It's really embarrassing.
Yeah, right.
And when they know you, it's, don't worry about it. Deal with it tomorrow. And I remember the first time that happened, I walked out, and I was like, wow. That is a place I want to come back to because there's a little bit of trust, although they know I'm there regularly. I mean, unless I'm flying away tomorrow to Venezuela to live the rest of my life there as an expatriate. But live
in hiding with that, owing that debt.
How much did I get them for? $3.37. Who knows?
See, but it also makes you feel then to leave them a tip for offering you that courtesy. Then you would then reciprocate.
That's true, but actually, to me, in many respects, more important than the single tip is the word of mouth, because now we have all these places where you can leave reviews. Yelp and lawyers have all these sites. Everybody can leave a review everywhere. It wasn't always that way, but still, even though you can leave these reviews, word of mouth is really important. And one person saying something horrible outdoes 500 people saying something nice. So it's important.
Mm-hmm.
All right. If we don't have any calls yet, let's go back. Last week we were talking about the Family and Medical Leave Act. And we did not get through the things I wanted to talk about, and so let's go back there. We talked pretty good detail about the remedies, the damages you can get, reinstatement, so we won't rehash that. But who's eligible for the FMLA? It's not everybody, and I'm concerned that maybe I misled people last week because we never really got to that part. We started focusing on remedies.
For the folks who may have missed last week's show, just touch upon what that is.
Okay. Mm-hmm. Family and Medical Leave Act is a federal statute that allows certain employees up to 12 weeks of unpaid time off from their job, and it's usually for either a serious health condition that you have or one that your immediate family has. And immediate family is defined as parents, siblings, children. It's sort of an extended to grandparents, although it's not really in the statute, but most of the cases now accept that. And so when you come back, your job is supposed to be protected, and you're supposed to be returned to either your same former position or, as we discussed last week, a substantially equivalent position, which really means almost the same duties, responsibilities, authority, benefits, compensation, opportunities to move forward. And if you're not, it's called adverse employment action, and it's a violation of the FMLA, which is what everybody calls the statute. One of the things that is important about the statute, before again I go into the eligibility, that we did talk about last week, is that it's an unusual statute in that the employer has the duty to let you know that you might be eligible. I don't know of any other statute, honestly, like that.
No.
If a supervisor hears somebody saying something to you that is sexually offensive, they don't have to come to you and say, you may just have been sexually harassed. You want to complain about it, you complain about it. But with the FMLA, as soon as supervisor, employer, as soon as they hear, whether it's from you or a coworker or scuttlebutt in the office in the lunchroom, as soon as they hear something that causes them to believe you might be entitled to FMLA, they are obligated by statute to offer you what's called the FMLA packet, which is the forms that you can fill out if you want to, and the medical certification that your doctor can fill out, so that the employer can review it and either approve or deny FMLA leave. So that is an important aspect of the FMLA. But who is eligible? First of all, it's only within companies that have at least 50 employees within a 75-mile radius of where you're working. So it doesn't have to be 50 employees right where you are. They could have another office, in the next county. As long as there are 50 employees within a 75-mile radius, you are protected under the FMLA. Anything less than 50 employees, unfortunately, you don't have that kind of protection. And if you need to take time off for something serious,
You have to work that out with your boss.
right, or they can fire you. It's very, in my view, Congress decided on 50 when they did because they didn't want to overburden small employers. I understand that. I don't think 50 is a small employer. Maybe that's just my perception. I would go down a little bit, maybe 25. The discrimination statutes are 15. So I think that's a reasonable number. But it is 50 within a 75-mile radius. Also, you have to have worked for that employer for at least 1 year. And within the last year, the last 52 weeks, you have to have put in at least 1,250 hours, which if you're full-time, you're definitely going to have done.
Mm-hmm.
If you're part-time, depending upon just how part-time you are, you may also satisfy that number. But those are three very important characteristics of eligibility. The number of employees that the employer has within the certain radius, whether you yourself have been there for a year, and whether, let's say you've been there 3 years, whether in the last year, the last 52 weeks, you've put in the requisite number of hours, which is 1,250. If you have, you're eligible. Most employers, in terms of employer eligibility, are covered. There are some that are not, but in my experience, there's so few that it doesn't really pay to discuss, at least on a radio show. If it comes up, in a consultation, it comes up, but it doesn't come up very often. As I noted, what does an employee have to say to get the FMLA leave or the FMLA packet? Well, first of all, you don't have to say anything. If your coworker says something and you can prove it and you weren't given that packet, it's a technical violation. It doesn't get you any big damages or anything, but it is a technical violation. It's interference under the FMLA. If you say something, if you go to your boss and say, my son has to have his tonsils taken out. Well, okay, it's not a big thing, but it's still a surgery, and you may be entitled to FMLA leave. The employer at that point has to offer you the packet, and you can decide whether or not for tonsils you want to fill this whole thing out, or whether if your employer is willing to let you take a couple days off, that's all that matters to you. On the other hand, if your spouse has cancer and is going to be having a lot of chemotherapy, radiation, doctor's visits.
Or leaving the area for treatment.
Right. Then you may need a good amount of time off, whether it's a block of time. You're going to Chicago to meet with a really big specialist, and you're going to be gone for a week. All right, you need a week's time off. Or you're here locally now, and there's the normal treatment, and you don't need a block of time off, but you need a day here, a day there, half a day here. That's called intermittent leave. And that is also something that can be applied for and the employer approves. And you have to give, if possible, reasonable notice of your absence. And sometimes if there's an emergency, it's not possible, and that is accounted for in the statute. So we talked about two types of FMLA claims, interference and retaliation. The retaliation is the big one, okay? The not giving you the packet, can be resolved very often by somebody complaining, even a lawyer sending a letter saying FMLA, and you get your packet. But now what happens when you're ready to come back from FMLA leave? Sometimes everything goes really smoothly. As a matter of fact, maybe most of the time it goes really smoothly. But too many times it doesn't.
Do you find that it goes smoothly when you follow the process versus if it's just sort of happening without the packet?
Well, I find it goes
I've got a quick question.
Okay,
Would you
sure.
like to take a news break?
That's fine.
Okay.
I missed it last time. Let's do it.
Well, we were on the phone last time. We're going to take a quick break for news. We'll be back with more Ask a Lawyer here.
1590 here at WPSL. It's Ask a Lawyer. Back to your host, attorney Stewart M. Address.
Okay, everybody.
Yeah, following that news, I don't know.
I don't have anything as funny as or as bad as the hamster story.
I don't. Do you think they got a case?
I hate to say no right off the bat.
Yeah, I had to ask you.
There are service. You don't have to be a dog to be a service animal, but Florida has very loosey regulations, and it's one thing if you have to be certified, then maybe you get your hamster certified. But if not, I don't think that the hamster's allowed to fly with you. Yeah, Florida is beginning, and as are most states, tightening up those regulations so that people know what is and isn't.
I've heard people complaining, though, about this so-called service animal, applying to just dogs, because now every dog is a service dog. It's my emotional support dog, but you're with your entire family flying. Isn't your family enough support? So,
Oh, no,
you
not
know,
always.
It's like, last time I flew with an animal, it was in a crate in cargo. So,
So some people fly with their family, they take alcohol. Others might need a service support animal.
yeah, I don't know.
Okay. I'm gonna sort of wind up on the FMLA. So if you're out there and you have any questions about the Family and Medical Leave Act, please give us a call. Even when we move on, you can give us a call. But be nice if you're out there now and you have a call, give it to us. Anyway, the last thing sort of on the FMLA is the burden of proof. The employee has the initial burden of coming forward and showing that some adverse action was taken when he was exercising or she was exercising a protected activity. And I see we have a call,
We do.
and it looks like it's Dan.
Yes, hello.
How are you, Dan?
Well, I'm very well, thank you. This is a question for a third party, actually, my son.
Okay.
When he was 17, he was arrested. The charges were subsequently dropped. He was during the time he was awaiting, he came home with an ankle bracelet, and then the charges were dropped. Well, he's got this record now that he was arrested, and that has precluded him from joining any military organization, and I suspect any of the more sensitive government jobs. So my question is, if he wasn't convicted, how in the world can we get rid of this record, if at all?
All right. First, let me give a caveat. I am not a criminal law attorney. So that is nowhere near my area of expertise. But I do have friends who are criminal defense attorneys, and we talk. I can at least tell you this. I know that you can get certain convictions expunged.
Yes, conviction.
I don't know about arrests, honestly.
Yes.
So it may be something for you to look into by calling, either a local criminal defense attorney or maybe calling the local Florida bar office, depending on what county, Martin County Bar, St. Lucie County Bar.
Yeah.
I just honestly don't have the information to give you an answer. If you want, I can certainly try to find out, and we can talk about it either next week, or I can try to have my paralegal get back to you. But it's just not an area that I practice in.
I'm sorry.
That's okay. Don't look. I'm glad you called, and if I can help, I'll be happy to help.
Now, was he a minor at the time?
Yes.
So I always thought that didn't carry over into your adult
Well,
life.
my understanding is if you're a minor, you can move to seal the records. In which case, go ahead.
When the military's doing a background check, they're going through the FBI, especially in today's environment. They're going through the FBI and so on and so forth, and so it becomes an issue. And so I was hoping that we could have this done. But if it's going to take more than this phone call, I'm going to have to defer to him and see how interested he is in making it happen.
Yeah, I wish I could give you a good answer to that. Unfortunately, it's been about 32 years since I took a criminal law class. I did pretty well, but I didn't go into that area of law.
I got you. Okay, well, thank you for your time.
Thank you for calling. I do appreciate it.
All right, sir. Take care.
Okay, bye-bye.
So 340-1590, anyone with any questions, or if anyone can answer his question.
Right, or if there's anybody with a question that I can answer. Anyway, so on the burden of proof for the FMLA, the employee has the burden of coming forward to show that something was done that violated his protected rights or retaliated against him.
Like his pay is different, or
he started out as a loan officer and came back as a bank teller.
okay.
Pretty different. So the employer then, if we're at a trial, they now have a burden to come forward with sufficient facts to show that the person was either fired or their position was changed for a legitimate, non-discriminatory reason. A reason it doesn't violate the FMLA, or if it's a discrimination case, a reason that's not based upon race, religion, whatever. Now, if they come forward with anything that is rational, you as the employee have a new burden. you have the burden of showing that employer's explanation, as a plaintiff's lawyer I would call it often an excuse, is a pretext, is make-believe. It's made up. It's not real. It's not why what happened happened. It's just they and their attorneys
That's what
getting
they're
together.
saying now.
Right. It's trying to put the best light on something that they can.
Right.
So you, as the employee, ultimately have the final burden. You have to persuade a jury. But when you make your initial showing, the employer does have a burden to come forward with something that a reasonable person could say, well, if true, then that's okay. And I do see those a lot. It's not, no case really is black and white. So people walk in the door and we have a consultation and I hear this great set of facts. And then I turn to them and I say, okay, well, what do you think your employer is going to say as to why X, Y, or Z happened? Now, sometimes you get the response I get from my kid, I don't know.
Right.
And you have to probe a little bit, do a little bit dental work, pulling some teeth. Something else I don't have a degree in. Or you do have people that come forward and say, well, I think they're going to say it was because I reached my limit in points for absences. I say, oh, well, tell me about that. Again, something that happened this week in my office.
Okay.
Is there a policy? Yeah, there's a policy. Do you have a copy of it? Yes, I do. All right, I look at it. It says, okay, 7 points, and you can be terminated. So I turned to the person, and this was an FMLA case, by the way, and I said, excluding the absences that you had that were protected, that are FMLA based, in the last 52 weeks, did you have 7 unexcused absences that would account for 7 points? And they had come in very prepared. They came in with a little chart that had all their absences, and so we started going through, okay, which are FMLA and which aren't FMLA? They had 7. And when I looked at that, I said to them, this is what's going to happen. We're going to make this great case. If we ever got to trial. They're going to come forward with this legitimate reason.
And their policy,
right.
which you agree to.
And we're not going to be able to rebut it. We're going to lose. So I said, while I think you're right, what they did to you, I think was motivated by the FMLA, by you taking leave. And in this particular situation, I really do believe that. However, the employer escapes because there was a legitimate reason that they could hang their hat on. And unless you have a smoking gun, unless you have somebody saying, oh, I was in the office when the general manager said, oh, well, this wasn't why we really fired him, but, we can use this instead. Well, unless you got something like that, you're not going to prevail.
And no one is going to jeopardize their job coming to your aid.
Not often,
No.
but there are some.
Yeah.
And that's what depositions are for,
And
trying
now
to pull truth.
you also have to look at the employer, because this is a person that now we can't depend on. They're always out.
Well, are they always out for protected reasons, or are they always out for unprotected reasons? What is the motivating factor? And if you do have evidence to help you figure that out, then you may have a case, or in this situation, you look at the person and you say, I'm really sorry, I wish I could help you, but unfortunately, I don't think you have a case because of this. Now, this person reacted very well. Didn't like, I've had potential clients storm out of my office. I came here for you to help me, and it's happened. Okay? I think it's happened to everybody, every lawyer. This person was heard. They were listened to. Their situation was analyzed in a way that they could understand. It was pointed out to them what the problem was, and they readily accepted it and said, all right, I guess I just have to move on. Now, when I heard that, I always say something else. So you need to get checked with at least one other lawyer, really. All right? I think I'm right. I'm pretty confident I'm right, but I'm just one lawyer. Lawyers have different opinions. And if you're about to have heart surgery, I don't think you would only check into one surgeon.
Right.
So if you have a significant case and you have a lawyer, whether it's me or somebody else, that first guy or gal telling you, you don't really have a case, go check with one other person, really. It's much better safe than sorry. And then at least if you get another person saying the same thing, you at least can walk away a little bit more confident that,
or feel like you got kicked in the gut twice.
Well, that I guess
what I
that's
was
true.
thinking.
Yeah, I guess that is true.
Oh.
So if these things, folks, ever come up, if you ever have a serious health condition, or you have a member of your family that has a serious health condition, keep in mind that if you are working for a larger employer, and it doesn't take too much to get to 50, you have rights. And there are times where, employers, I can't give you 2 weeks off. And they either don't care or they don't know about the FMLA. And sometimes you can educate an employer and then they're okay with it. They really didn't know. Lawyers don't know everything, and employers don't know everything about the law, and there's no reason to believe that's not true. But then there are employers that just, don't care. And if they can get away with it, they will get away with it. And that's when you need to know a little bit about what your rights are, and at least check into it, because this is a serious area. We get lots and lots of phone calls.
It's
on the
sad, though, to
FMLA.
think that that it has to be this formal, that it can't be that your employer just cares about you enough to go, you're having a problem right now, and here's the steps that we need to take to fix it. Let us know what's going on, and we'll all work it out.
I completely agree with you, and I think in the days that my late father came from, where you would work for a company for 20 years,
Your whole life.
30 years,
Yeah.
I don't know. I mean, he's not here for me to ask him anymore, and maybe some of you out there have an answer. If you're that generation and you worked for a company for 20 or 30 years, I would like to think that it was those employers who would be more understanding, even there wasn't a law like this then, but who would be more understanding of their employees' legitimate needs and try to take care of them, because if you've been with the company for 10, 15 years and you're on a lifetime track, I think you want a happy employee, you want a productive employee, you don't want a miserable employee. But the same could be said for today. A happy employee is a productive employee, and a miserable one will do the least amount of work possible to get through the day. And if you want production, in one way or another, you have to make sure your employees feel that you care. I mean, it's either the money you pay them, or it's the time off that's available, or the flexibility. Look, my office is really small. It's myself and my paralegal. My paralegal, calls me one morning and says, my daughter is sick. I need to take her to the doctor. Is it okay if I come in at 12? There is not a single time I've ever said no. It would be ridiculous. In my view, it's absolutely ridiculous.
Well, it might be a little hectic until she gets there.
Yeah.
But you get through it.
I'll hold down the fort. I'll go back to answering those calls.
Or just you put the answering machine on
Right.
and come in late.
And I know for a fact that one of the reasons she's been with me for the length of time she's been with me is because of the flexibility, is because it's quote unquote family friendly. It doesn't need to be a 1 or 2 person office for that to happen.
Right.
You can have a good number of employees and be a family-friendly business and understand that your employees have real needs at times. And if you accommodate them, you're not only making a happy employee, you're not only getting more productivity, but you're developing a loyal employee. And that's just worth it.
And I think that if someone comes to you and says, I'm going to need this chunk of time off, they're pretty much not going to the Bahamas.
We hope not.
Yeah.
When I task my paralegal,
That would be called vacation.
Yeah, if I'm not going to be in the office and I have some bank deposits to make, and I ask my paralegal to fill out the deposit slips and take it to the bank, usually I say, by the way, if it's a Friday, please make sure you're back on Monday, from the Bahamas.
Yeah.
Just don't spend it all. All right. The next area I thought we would talk about is minimum wage and overtime. Wage an hour. I can tell you that I get more calls about that than I do about the FMLA, and I get a lot of calls about the FMLA. Wage an hour we'll have calls 5-10 a week.
So there's a lot of people out there working, feeling as though they're being not treated fairly.
Yes, and it's usually overtime.
Okay.
Usually the call we get is not, I'm not being paid the minimum wage, because that's just stupid. I mean, and an employer can't even claim I don't know. It's just stupid.
Mm-hmm.
So we don't usually see that.
But there are people who are employed making less than the minimum wage.
Oh, sure there are.
Okay.
There are a lot of the undocumented workers will be paid under the table, and they'll accept it because they're afraid of complaining, or they're afraid if they complain that they're going to be deported. It's also difficult for them to complain because although they have rights to go into court, even though they're undocumented and not citizens, they have just as much right to file an FSLA claim.
Well, I'm not understanding how they're working without a social security number, because that's one of the
they have
first
one.
things. Oh, okay.
They have one, but it may not be theirs.
Okay.
Okay, and that's the problem. They may have a real claim, and they're entitled to pursue it in court.
Yeah. How do
But they don't have the protection
Okay.
of not being reported to. It used to be INS, whatever it's called now, because obviously it's going to come out that they're undocumented. The Social Security number was wrong.
So right now I'm sitting here not thinking much of those employers.
Well, that's true, and those employees really don't want to come forward.
Okay.
Okay, that's the reality. But there are a lot of people, most of the people, who are working with real Social Security numbers, and they're making the minimum wage and hopefully a lot more. And they find themselves in overtime, particularly overtime situations.
Okay.
And there are a lot of rules when it comes to overtime, but the basic principle is really very simple. It's where you get into the exceptions that lawyers are created. I mean, I have like an 8-volume, treatise on wage and hour in my office. It's all of it with exceptions.
I have an example for you,
Okay.
and I'm gonna name names. My mother worked many years as a department manager for Kmart.
Okay, Mart, okay.
She would be over her 40 hours.
Mm-hmm.
She'd have to clock out but not go home.
No.
But it was a situation where you ran your department, you had the hours, you're not going if you'd like to keep your job.
Yes.
So there's an example. And it's a big company. Was a big company.
That's among the examples. I mean, I hear from people who, when I get in, I can't clock in once I get in. I have to first go get changed, and then I can come clock in. Well, if changing is a requirement of the position at the job site,
Right.
then it's compensable time. You're allowed to clock in when you walk in the door. If you were supposed to get dressed at home and you didn't, that's another
on you.
story.
Okay.
At the end of the day, if and we're talking about like clock out, this is like the old standard. There's a punch clock. It could be done anyway. It could be on computer, it could
Right.
be hand, whatever. But you clock out at the end of the day, and the employer says, wait a second, I need you to do something. Okay, but it's compensable. So then I'll be told, well, I wasn't allowed to add that time in because I'd already clocked out. No, can't do that. All right, the employer has to pay you. If you're working 30 hours a week, maybe it's not going to be an overtime situation. It's just a situation that you're entitled to additional hours.
This was them trying to keep their overtime from. It wasn't happening. Right. They weren't paying it. They just weren't going there.
And there are a lot of ways to try to get around that. Some legal, some not so legal. And I see we're probably coming close to the end, and we won't get very far through this wage and hour. So let me just give a little basic summary, and then we'll really touch upon it next week. The two basic things to know are there are exempt and non-exempt employees. Non-exempt employees are entitled to overtime. Exempt are not. What's the difference? If you're an exempt employee, you're entitled to be paid a salary. Okay? If you're paid a salary, it's for whatever hours are necessary to get the job done. If you come in late, you still get your salary. If you're docked, then the employer has a problem. If you need to take a half a day off to go to the doctor, you still get your salary. Okay, you can't be docked unless it's at least a full day's absence. What is the difference? What makes a person exempt or non-exempt? There are probably about 100 exemptions, but 3 of them comprise more than 90% of all cases. And those are the 3 we'll really talk about next week. They are called the administrative exemption, the executive exemption, and the professional exemption. And they all have specific requirements, and it's really very clear how much you have to make, what your duties have to be to qualify for this exemption. If you qualify for the exemption, then you're not entitled to overtime. If you don't meet all the tests of the exemption, then you are a non-exempt worker that has to be paid overtime. Overtime is time and a half for all hours over 40. Now, what if you're paid every 2 weeks and 1 week you work 45 hours and the next week, they don't want to pay you overtime, so they only let you work 35, and you have 80 hours on your time on your pay stub and you're paid for 80 hours at straight time. That's a violation. It's considered, doesn't matter how you're paid, bi-weekly, tri-weekly, quad-weekly, I don't care. FLSA is based upon a week. And so if 1 week you work 45 hours and you're a non-exempt employee, you're entitled to 5 hours of overtime at time and a half, even though the next week you only work 35 hours. So that's one of the important considerations. Another important consideration is that if you are going over, your employer cannot say, I'm going to give you a vacation day instead of paying you overtime. I'll give you some extra personal time or whatever. There's a lot of things that employers have traditionally offered which are no longer permissible. They're not legal. Okay? You cannot get anything in lieu of overtime. You must be paid your overtime. There are employers that have policies, legitimate policies. No overtime without prior written approval. That's a legitimate policy. You work 41 hours and you didn't have that prior written approval, you're entitled to overtime. The employer can then fire you for not following that policy, but if you work that extra hour, you are entitled to overtime. If you go take a regularly scheduled lunch break, my paralegal gets an hour. If during that hour I say, hey, can you get me the file on such and such? It may take her 30 seconds. That hour is now compensable. I did not leave her alone for her lunch break. You're entitled to your lunch break. It's one of the reasons some employers have a policy that when you go to lunch, you go to lunch. You leave this building because the temptation is too great, depending upon what happens, to ask a question. And we all get into trouble doing that. So there are a whole host of things that we're going to discuss. If you work at any job and you are not on a salary, you are probably entitled to overtime. If you are on a salary, you may still be entitled to overtime because you may not be properly a salaried exempt worker. And then we get into the whole issue of, is a worker properly classified as exempt or non-exempt? And sort of as we wind down, and I don't want to miss this because I was listening to it before. When Cliff was talking during Swap Shop about the upcoming Ask a Lawyer show, I loved the way he said it. It's upcoming. It's Ask a Lawyer, and I thought to myself, he should have followed it with something else. Ask a lawyer, and let's get ready to rumble. All right, we're running out of time, and I want to say goodbye to you all.
Stewart address. Tell us where your Stewart address is.
All right, my Stewart address is 611 Southwest Federal Highway, Suite A in Stewart. It's right on US 1. It's a beautiful building with a green roof, and our office number is 772-781-8003. Call us. We're happy to talk to you.
Great. Website?
Website, www.stuartaddresslaw.com.
That's very easy to remember.
Spelled like the city, Stuart.
So we'll be back next week with more Ask a Lawyer right here on WPSL Digital 1590, the talk of the Treasure Coast for 25 years and counting.